Hi, this is Judge Herb Dodell. What I decided to do today was to just tell you a great story. As an illustration, of course. Many people are involved in personal injury matters, whether they're slip and fall or auto cases, and they can go lots of different ways. This case was kind of interesting because I got called on a Thursday from a friend of mine in San Francisco who said that he had a trial coming up on Tuesday and he couldn't make it. Could I try the case for him? It was in San Jose. And the problem with the case, and now I understand why he didn't want to try it, she had 5 prior accidents. And then she had 3 after this one. And I got the one in the middle, and she was hit at 5 miles an hour. And so, of course, the insurance company took the position she was already hurt, which actually worked for our advantage because there's a concept in the law called the thin-skulled plaintiff, meaning you find the plaintiff in whatever condition you find them, for better or worse. And some people who've had prior accidents, instead of looking at it from the negative, say they were now more susceptible to greater injury with less impact because they had a prior existing condition. And in our case, she had lifted a 50-pound cauldron of soup the night before the accident which was being tried. And she was fine. And she didn't have any problem with her back or anything else. So we go to trial, and I'm trying to think of a way to demonstrate the susceptibility, the thin-skull plaintiff theory. So I go to Pier 1. I remember it was right near Stanford University. I remember going, I had never been to that town. And I went to Pier 1, and I asked the manager if he had any broken glasses. You know, cracked, drinking glasses. And he said, yeah, we take that stuff and we put it in the back. So they went back there and he found a glass that had a crack in it. And there was also one that it was totally undamaged. So I brought them to the trial, to the closing argument. I put them on the table and I covered them with a towel so nobody knew it was underneath. And I had a little hammer. Took off the towel and they just tapped the one with the crack in it on the crack. And of course it shattered. Then I took the second glass, I tapped it. Nothing happened. I was being very careful of how hard I was tapping it. And I used the illustration that, see, she had a crack in it already, and that's why she suffered the damages that she suffered as a result of this accident. And guess what? It worked. The jury bought it, and my client got a verdict. My friend in San Francisco was shocked, and I kind of was shocked too. But that's an example of using demonstrative aids and demonstrative devices to prove a point. It's the same thing with videotapes. I often took depositions on videotape, and then you just go out and you edit it and you run a 30-second clip. It's so much more impressive to a jury to see something like that than just hear somebody come up there and testify, or reading out of a book or a deposition transcript. So we talked about demonstrative aids before, but you have to keep in mind this is a creative way of doing it. You have to have a lawyer. I'm going to talk about picking a lawyer in probably the next episode. So if you have any questions, you want to know more about any of this, what's admissible, what's not, when does it come in and when doesn't it, this is information that can be very valuable to you because you may have a piece of evidence, you don't know if it's going to get in or not. You need to know. So contact me at askjudgeherb@gmail.com, or you can find it in the book. It's called From the Trench to the Bench, Navigating the Legal System and Finding Your Spiritual Path Along the Way. So hope to hear from you real soon.